Ladies and gentlemen, thank you for taking the time to be with us today for the M&A Academy program and our fifth webinar in the 2025 series. My name is Purti Minawala and I'm a partner in Khaitan's corporate M&A group. I would like to extend a very warm welcome to this webinar to every one of you, whether you're in our audience in India or around the world. The M&A Academy program is designed to provide functional legal knowledge and understanding on M&A transactions and processes to anyone interested in M&A in India today. Our subject today is Acquihire M&A Deals. On this slide is the agenda for today's webinar. We will have a panel discussion followed by a Q&A. While we already have received several audience questions, if you do have questions, please submit them using the facility provided in the webinar portal. You can either address them to me or Vivek, and I'll pick it up as we go along. If we cannot cover all the questions during the webinar, we will respond offline by email right after the webinar. Please note that summary notes of the discussion and a recording of the webinar will be sent to you after the webinar as a matter of course. M&A in India is an important part of a firm's practice with more than 50 partners dedicated to this area because India is experiencing massive growth in M&A transactions. In this webinar, we'll explore one of the most dynamic and increasingly relevant trends in India's M&A deal-making space, the acquihire. As many of you will already know, acquihire transactions, where the primary asset being acquired is the talent rather than the underlying business or IP, have gained tractions in India, particularly in the technology, fintech, and startup ecosystems. These deals raise unique legal, commercial, and cultural issues that differ significantly from any other traditional M&A deal. Today's session is tailored specifically for M&A executives, in-house counsels, and deal strategists who are navigating this evolving space. Whether you're evaluating an acquihire as part of your talent acquisition strategy, advising on structural considerations, or grappling with regulatory and employment law challenges, this presentation will offer practical insights grounded in current market practice. With this, let me do a quick introduction to who I'm participating with today. Everyone who has registered for this webinar should have received by email already a summary of the speaker and his credentials to talk today. So I will not spend much time introducing him. Suffice to say that he is an expert in the field of M&A and the right folk to be speaking with us today. Our presenter today is B.N. Vivek from our Bangalore office. With this, let's get started with the presentation. Over to you, Vivek.
Thank you so much, Purti. Hi, everyone. So, as you all know, today's session is on acquihires in India. So, what do we really look at when we look at an acquihire? It is right to just look at the etymology of this word, acquihire. It is an amalgam of two words, which is acquisition and hiring. So, as it's right, it's therefore an acquisition of employees that is primary concern when we look at an acquihire. So today's session, we would cover aspects around acquihire. I will give maybe a brief overview of what an acquihire really means, where acquihires are really seen in our experiences. We'll then go into typical acquihire deal cycles, explaining what it is to look at acquihires and what we really do in an acquihire deal. Some of the aspects of the acquihire deal cycle will include legal due diligence, structuring aspects, documentations, approvals. These aspects too we'll cover during the course of this session. Without much further ado, let's start with what an acquihire really means and some of the key aspects to note around what an acquihire really means. Next slide, please. So as I mentioned, the intent of an acquihire really at the core focus of this transaction is to secure human capital. Human capital, as we all know, is an important asset for any organization. And therefore, securing human capital becomes increasingly difficult when you're looking at complex organizations or complex industries with niche know-how skills available or with limited availability in the market. So it is important that organizations look at human capital, build cohesive teams, and therefore look at teams with proven cohesion in the market and maybe acquire those teams in a way to organically grow as well. Now, what are the motivations for a company doing an acquihire? Why would someone want to go out into the market and acquire a team as against going out in the market as usual, putting a job description and asking people to apply for the role at hand? One, obviously, it's a function of cohesive teams and proven capabilities of a particular team. And therefore, it would be right that the organization looks at such teams and acquires the entire team as a whole, such that they are able to come into the group, start run the ground hitting hard, and in a way that they are able to develop the in the way that they are able to develop systems and in the way that they are able to develop the product without further ado. That's for the buyer. Now, what is it in it for the target? The target might be facing difficulties of its own. They might be facing issues around fundraising. They might be facing issues around people leaving the organization with limited team capabilities going forward, which might not meet the organization's long term needs. Then the team itself might be significantly small and they might be looking for a larger player to really help skyrocket the product that they're developing into the public market or into their customer base. So all of these are reasons why a target might be looking to an acquihire and why a buyer might be looking to acquire teams, and one team that is high performing, pre-built, and something that is working cohesively as a unit to hit the ground running hard. Some of the industry examples that we've looked at in an acquihire include when we've worked with large IT companies who have taken over employees as a whole when they take on customers, because the customers really end up moving the IT workforce to the IT company. That is example one. And example number two could be a more specific startup based example where a healthcare organization ended up acquiring an AI entity so as to help with scheduling doctor appointments and ensure that the doctor appointments and doctor time is utilized in a more efficient manner, such that they're able to take on more appointments within a given span of time. A similar example also is when we helped an e-commerce entity acquire another technology company which helped undertake online trials for clothing brands. So in each of these cases, one common thread really is the fact that there is a ready team at play. In most instances, it also happens to be that the acquirer may need more time to really build the capabilities in-house rather than go out and acquire a team that is ready and at play and develop the same product come in-house. Next slide, please. So when we look at this, acquihires are therefore commonly popular when we look at people-centric roles, which is IT, ITES, and consulting, and similar roles. Then also where there is research and development at play, or where there are niche skills at play, which could include of late AI, there is cybersecurity, and similar industries where there are very niche skills that are required to perform the job at hand. So now that we've understood what an acquihire really means, let's go to the next step about what a typical acquihire deal cycle looks like and what does a deal really entail. We've split this slide into two colors, as you can see, in dark and light blue. So the dark ones are what a legal counsel would generally assist you with. The lighter ones are fairly important aspects as well. If not fairly more, it's significantly more important for business teams to be informed about some of these steps. You start with identification, where you identify the target. It is important to ensure, uh, as it is time and again business wisdom, to ensure that there is cultural fit between the organization that is acquiring and the team that is being acquired. There should be desired talent, the talent that should be that is proposed to be acquired should be a right match for the skill set that is desired to be plugged in. So that takes care of the identification part of it. Then there is the due diligence, where now due diligence, there could be multiple aspects of a due diligence. We would do a legal due diligence, there would be an accounting and a tax diligence, and then there could be an employment specific diligence. In some instances where IP is being acquired, there could also be specific intellectual property or IP diligence being conducted on the target um, and the asset at play. You then have integration planning. Now, this is where the business team and the HR come in, where they look at how this acquired team will integrate better with the acquired or with the buyer organization. And that's where integration planning plays a key role, because an acquisition is made or broken based on integration of this team. You then have deal structuring. Now, we'll step into deal structuring in a minute, where we speak about how the deal should be structured, how the consideration should be paid, what are the various ways in which an acquihire really works or doesn't work. We then get into negotiation. Once the deal is structured in a way that is palatable to both the buyer and the seller, then you look at negotiation in a way that what should be the right price, what should be the right reps, warranties, what is the expectation of the buyer, what's the expectation of the target entity. All of these are important to sort out during a negotiation so that parties are clear of what is required of them. We then get into documentation, which is to put pen to paper in terms of what was negotiated, what was discussed, and cover possibilities for the transaction and for the asset as a whole. Then we come into closing and transition and onboarding. Closing of the transaction is typically where you would look at transfer of consideration and the employees moving from the target organization into the buyer organization. Then once they move into the organization, starts transition and onboarding, which you would have in a sense thought of when you look at integration planning in the third step. Now once you've thought of the integration planning in third step, now you're implementing that integration planning when you look at transition and onboarding of employees, where you go through training mechanisms and therefore enable the employee with the right skill sets to hit the ground running hard. Next slide, please. Over the course of this session, we would look at some of the key aspects that we lawyers would look at when we look at an acquihire deal. We will also look at some of the key concerns that we would have noticed over the many acquihire deals that we would have done. To start with, let's start with legal due diligence. In a legal due diligence, we would typically look at employment arrangements, we would look at intellectual property, liabilities, agreements, and data protection. Now, in employment arrangements, because your main focus and main asset in this case being the employees of the target entity, you would want to ensure that the actually employees actually exist in the target entity, right? You would want to ensure that the employees have signed employment agreements with the target entity. They are ready and willing to move to the buyer entity, and are and possess the adequate skill set to undertake the employment or at the acquirer. You then get into intellectual property. In intellectual property, you would want to establish the chain of title of intellectual property that is developed by the employee at the target entity. Intellectual property comes into fore only if, along with the employment of the employees, you're also acquiring intellectual property. Most, if not all, acquihires involve an acquisition of intellectual property. It's not to say that the intellectual property is the cornerstone of this transaction. It's rather the fact that the team has built certain know-how while they are in their current role. So instead of really rebuilding that know-how, it is important that this know-how is acquired such that if that know-how is relevant in the scope of services that are being provided by the employee going forward in the buyer entity, then the employee can make use of this know-how and therefore develop the systems and complete the work at hand in a much faster scale as compared to building it all ground up. When we look at intellectual property, some of the key aspects that you would look at in a diligence would you would want to establish chain of title, which is to say that you would want to ensure that the employee has in fact transferred intellectual property or assigned intellectual property onwards to the target. And then the target in fact continues to own that intellectual property. And once you ascertain that, then you would want to make sure that the target is able to transfer or assign that intellectual property onwards to the buyer entity. This chain is important to establish so that you are therefore paying consideration for the right know-how and the ability to use that know-how going forward. Then you get into liabilities. Now, liabilities could be of two forms in an acquihire. Typically, liabilities could be in the form of contractual liabilities, where you would look at typical suppliers, customers' liabilities with agreements that they have executed with third parties. And therefore, it is important to understand what form of liabilities the company has outstanding to see if the company or the target entity has the ability to settle those liabilities. And then finally, ensure those liabilities are settled either on or prior to closing or latest post closing in a way that is satisfactory to the buyer entity. The other form of liabilities really are employment liabilities. Now, when you speak about employment liabilities, you would want to ensure that the employees have been paid adequately, have been paid in accordance with their employment contract. There are no outstanding dues that are payable by the target entity. Those are important aspects to ensure and cross check, because once the employee moves over to the buyer entity, you wouldn't want the employee making claims against the buyer entity for past dues. Then we have get into agreements. Now, within agreements, you would look at vendor contracts again, you would look at supplier contracts. All of these you would look at only if you are looking to novate or assign those agreements onward to the buyer. If any of these agreements are meaningful and would be relevant for the team that is being acquired to perform their services, then you would end up novating those agreements. And therefore, when you novate, you would want to ensure that the terms are satisfactory to the buyer entity. Given that employment is a cornerstone, another aspect of the agreements is also to ensure that the employment agreements executed with the employees that are proposed to be transferred also ensures that there are no post-employment restrictions in the form of non-compete, non-solicit, or any form of golden parachutes. This is to ensure that the target entity doesn't have any claims, nor does the employee have any claims post-closing once the employee is working with the acquirer. We then step into data protection. In data protection, again, as you know, there are two types of data. You would look at personal data, non-personal data. To the extent of non-personal data, it is simple to solve because those forms of data is either just know-how or intellectual property, which is typically non-registered, and therefore you would enter into what is called an IP assignment agreement to transfer such non-personal data. To the extent of personal data, however, it is a different animal with the impending enforcement of DPDP Act. In case of the data protection law, we will need to ensure that adequate consents are obtained if any of the personal data is to be transferred, and particularly personal data of either customers, suppliers, or even the employees themselves. Those consents are necessary to cross-check and ensure that the target entity has adequate consents. During the diligence, you verify those consents are available, at least on a sample basis, and then ensure that you effect the transfer accordingly. Another common aspect of data protection is also data security practices. You would want to ensure that when data is collected and stored at the target entity, it is collected and stored in a manner that is compliant with best data security practices, which is compliant with Indian data protection law, which is applicable today, which is the SPDI, or in the future when the DPDP Act is enforced, the DPDP Act. Another aspect of due diligence which I want to cover is on litigation and any form of disputes. To the extent that the target entity has any outstanding disputes, it is important to ensure that those disputes are settled prior to closing and not necessarily left hanging for the buyer to then settle post closing. Typically, we've also seen employees come in post closing against the buyer saying that there were past dues that were outstanding, or there was a in one instance we noticed that there was a former employee of the target entity who then made a claim against the buyer entity saying, look, I was terminated without cause, and therefore now you need to reinstate my employment or provide salary for past work or for the duration of the period when he was unlawfully terminated. So you would want to avoid such circumstances and therefore conduct a thorough diligence on any form of disputes that are outstanding against the target entity. Next slide, please. We then get into structuring aspects. In structuring, you would look at the most common form of structuring, the most important form of structuring, which is the consideration that is payable on the deal, right? You would look at allocation of the consideration and how do you allocate consideration between varying parties. Typically, in an acquihire, you are acquiring a team of people, and therefore you would want to ensure that the team that is being acquired is adequately compensated for. This compensation could come in the form of signing bonus, retention bonus, or earnouts and ESOPs. In each of these cases, we will step into each of these instances in a minute and the implications or considerations that we need to be aware of when we look at employee compensation. Another aspect of consideration is the fact that if the target entity has investors, it is likely that the investors would also want to see a return on their investment, and they would definitely not want to write off their investment. In which case, some form of compensation may also have to be routed to the target entity. How do we route that consideration into the target entity? It is in the form of solicitation fee. A solicitation fee is a fee that is paid by the acquirer or the buyer entity to the target as compensation for having built this team, built this cohesive unit, built certain know-how, and therefore is able to transfer this unit and know-how onto the buyer. It is a consideration for such a transfer, and that's called the solicitation fee. Then you would look at IP. While we did speak about employee transfers, there is also the IP element. If there is an intellectual property that is being acquired, then the intellectual property that is being acquired also needs to be compensated for which there should be a consideration that is paid against the IP assignment. You could also look at license of that IP and not necessarily acquire the IP through our assignment, in which case a license fee could also be structured, where the license fee is paid over a period of time. And if required, at the end of the license period, you could look at acquiring the IP together with a flat out consideration. Now, going back to the employee forms of consideration that we spoke about a minute ago, we had the signing bonus, we had the retention payments or earnouts, and then we had the ESOPs. Signing bonuses are typically paid out on the day when the employee signs the employment agreement. Retention bonuses are paid on based on milestones. So if the employee or if the unit or the company performs in a particular way, then they are able to receive certain fees called the earnouts or retention payouts or bonuses. This could either be business linked or could just be linked to the period the employee continues to be employed with the acquirer entity. You then have ESOPs. ESOPs typically in India are structured as employee stock options under the Indian Companies Act. And then you would typically issue stock options to those employees through the entity which is issuing stock options. A complexity there could be when the entity is a subsidiary of a foreign entity, in which case you would be looking at employee stock options being issued by a foreign parent. There comes in Indian exchange control laws. You would want to ensure that the ESOPs being granted to the target set of employees is kosher from an Indian exchange control standpoint. Some of the key typical terms that you would look at when you look at Indian exchange control laws is one, you would want to ensure that the employees are receiving ESOPs on a globally uniform basis. Second, ensure that if this is cash based or cashless based, there are certain filings that need to be made upon exercise of the ESOPs, and those filings need to be done. We then move on to employee transfers. Employment transfers can be done in two parts. You could either look at transferring the entire group of employees as a whole, or could look at individual hiring. In case that you're looking at a group hiring, you would look at moving the undertaking as a whole. Typically, that comes with its own implications, one under tax laws and second under employment laws. Under tax laws, whether or not you meet the slump sale test is one consideration. Under employment laws, should you be moving an undertaking, then the employees that are moving along with that undertaking need to be compensated for in a manner that is no less detrimental to the employees as they were otherwise receiving compensation in the prior role or in the target entity. That was for group hirings or when you're transferring the undertaking. There's another typical form in which we also move employees or rebadge employees, which is that each of the employees resign at their own volition. And once they resign, they get an offer an employment with the acquirer entity. We typically use this latter approach when we are looking at smaller teams. This becomes slightly more complex when we're looking at larger teams, when there are one or two employees who might not really want to make the switch to the acquirer entity. In which case, those employees will need to be compensated for and released from employment or be considered for other employment opportunities within the target entity. The other aspect of employee transfers is the settlement of dues and waivers that you would need to obtain. It is important that the employees have received due consideration for their past work. Any form of statutory benefits are paid for timely and in a manner that there are no outstanding dues, penalties, interests that are payable under the respective statutory benefit codes. And then, as a matter of importance, the buyer should also insist on the target entity executing a release letter with each of the employees, where it confirms that it has no dues against the employee or the employee doesn't owe anything to the company. And similarly, the employee confirms back to the target that the employee doesn't have any further claims against the target entity. This is done as an additional cushion so as to ensure that there are no future claims arising from this transfer for the period prior to the date when the employee joined the buyer entity. We then get into IP assignment or license. In IP assignment or license, as I mentioned, we could look at either assignment of intellectual property or license of intellectual property. We would typically look at an assignment or a license in the context of how important the intellectual property is. It can either be assigned or licensed depending upon the business needs at that point in time. Data transfers we've spoken about as a part of the legal diligence, where the data will be transferred onwards with due consent and necessary process, including data security, onto the buyer. A key point on data transfers there is on data security. During diligence, it is important to ensure that the security standards are matched between the buyer entity and the target entity. It shouldn't so happen that the target entity has higher standards of data security, whereas the buyer entity has lower standards, in which case you would want to look at uh, any of the consents that you've obtained uh, from any other individual uh, of whose data is being moved and ensure that there are no standards that you've committed to when you've acquired the personal data. Then comes target winding up. Once you've moved the employees, the target is really of no use because typically, if it's a smaller organization or smaller setup, and if these were the only employees with the target entity, then you would want to ensure that the target is wound down, and therefore there are no further claims that is being made by the target entity. And typically, therefore, the buyer entity would insist that the target entity be wound down in a time-bound manner post-closing. Next slide, please. So we then move into what would be considered as documentation. Next slide, please. In documentation, we would be looking at a solicitation agreement, an IP assignment agreement, and then the employee documentation itself. We've spoken about solicitation fees that is to be payable, and therefore you record the solicitation aspects in the solicitation agreement. It's a very simplistic agreement which merely records the fact that the target entity will ensure that the employees submit adequate documentation, the target entity waives any rights against these employees and ensures that the employees are moved and facilitated in a way that they are able to work cohesively as a unit post the acquisition. You then look at intellectual property assignment, which is again any other typical intellectual property assignment to meet the needs of the intellectual property that is being transferred. And therefore, you record it to the extent that any of this intellectual property has been registered. You may need to file this intellectual property assignment subsequently with the relevant registrar or the governmental authority. Now, in respect of intellectual property assignment, it is important to ensure that the consideration that is being paid in respect of intellectual property is distinct from any other consideration. This will ensure that you are attributing a particular value to the intellectual property, which is required both from a tax law standpoint and also ensures that you are able to enforce the IP assignment in a more friendly manner. We then get into employee documentation. In employee documentation, you would look at the entire chain in which the employee is transferred. If you're looking at moving the entire business undertaking, then that would get covered in a solicitation agreement where the employees are considered to move as a team. And therefore, with the employee, you would only execute a tripartite agreement where the employee, the target entity, and the buyer entity execute one agreement which records the fact that the employee is moving over, that the employee doesn't have any claims either against the buyer or the seller, and therefore is ready to move. Subsequently, the employee also signs an employment agreement which records the terms of their employment with the buyer entity. In respect of a resignation and hire, this approach is slightly tweaked, where you would first require the employee to submit a resignation letter. Then the employee and the target entity execute a waiver, release, and no dues letter. And lastly, the offer letter or employment agreement is executed with the buyer entity. That rounds up largely the documentation aspects of it. But one key element that we missed out all this while is any approvals that you need. There could be two forms of approvals. One is corporate linked approvals, which could typically be the board and shareholders' approval, depending on the size of the transaction. Then you might need to make disclosures to the stock exchange. To the extent of those disclosures, those are aspects that need to be considered too. The other piece of it is the regulatory aspect. In highly regulated industries, be it in telecom, be it in atomic research, military, and the like, you might necessarily need specific governmental approvals or specific sector-based approvals uh, in terms of an acquihire, not so much to move the employees, but rather to move any form of know-how or intellectual property, in which case such regulatory approvals must be obtained prior to closing the transaction. Next slide, please. So by and large, what we rounded up during the course of this session has been that we spoke about how an acquihire deal cycle works. We started off with identification of the target, we did diligence, then we got into structuring, negotiation, documentation, closing, and integration aspects. We then did we then considered some of the key aspects that you would look at in a legal due diligence. Some of the common considerations that you would look at during structuring, some of the pain points when we draft transaction documents, and how to implement that structure in terms of documentation. That, by the way, was the key takeaways from this entire presentation. Next slide, please. As we look at the future outlook, what does acquihire really mean going into the future? We would look at continued growth of acquihires with the growing need to build niche markets and with niche skills available with the employees of late. You would look at building cohesive teams and acquiring cohesive teams so as to the develop your larger organization. There is also an evolving legal landscape angle to the future outlook. All this while, we've been considering age-old laws in employment laws, be it the Industrial Disputes Act or Shops and Establishments Act and similar such statutes. Some of these statutes will be replaced in the due time in the form of the labor codes, and those are things that we need to watch out for as well. That's it from me. Thank you so much for being a patient audience. Over to you, Purti.
Thank you so much, Vivek, for such an intense presentation. It was really good and fairly detailed. Must agree that all of us learned something today with you. Vivek, the chat room has been buzzing and we have a lot of questions for you. Everyone, what I'll try to do is I'll pick as many as possible. If time is short, as mentioned before, we'll pick it up offline and send you the responses over. Please bear with us there. Vivek, the first interesting question that has come along our way, what are the concerns when there's a cross-border acquihire deals? How do you work with that? What are the typical issues you've seen, and how do you deal with that?
No, thank you, Purvi. That's interesting. So when you look at acquihire deals in cross-border situations, you would typically look at an Indian acquirer, I would guess, is that should be the question, and therefore you might be looking at a target which is located outside the country. In which
Mm,
case, Indian acquirer will need to ensure that they have a physical presence outside the country to begin with, right? And therefore comply with the local requirements of the foreign country, ensure that they have the entity of presence there, and then consummate the acquihire there. The other way to really do it, and oftentimes we've also seen, is there is a facilitation process for those employees to transfer over inbound into India. Then there are the visa control regulations that also step in. Those are aspects that need to be considered. As far as outbound acquisitions are concerned, then again, it's the same aspect in a reverse way, where if there is a foreign acquirer and the target is an India entity, the foreign acquirer needs to ensure that there is physical presence in India through the form of legal entity, legal substance, and therefore complete the acquisition. Or if the intent is for the employees to move to foreign lands, then visa control regulations of that foreign country should be considered.
Fair enough, Vivek. Vivek, the next question is actually very interesting. It says, what are the risk member of the team members leaving after an acquihire acquisition, which is of course designed to focus on those members? And how do we mitigate, if we can, contractually, what should we do to mitigate that risk?
Right, right. Um, in terms of, I think, risks of team members leaving after acquihire, there are two ways you would typically see. One, obviously, the legal route is non-compete and non-solicitation exclusivity clauses in an employment agreement. Now, there, post-employment non-competes are typically difficult to enforce here in India, and that needs to be considered unless and until we tie this back to any transfer of goodwill during the course of an acquihire, in which case we could look at a post-employment non-compete enforceability. Um, Other than this, a more business prudential outcome would be to link any form of consideration to the period of the employee having worked in that organization, right? And therefore ensure that there are earnouts, there's escrow mechanisms that you can put into play when you structure the deal.
That should keep them motivated enough to ensure the employees stick around. Vivek, the last, I think I'll club two questions here because they sound more on the same level. One of the questions is, can we selectively hire employees without triggering employee-related liabilities under Indian labor laws, which is like your gratuity and other benefits? And or mandatorily, do these liabilities have to continue the way it is? How do we solve for that aspect?
Oh, interesting question. In case of gratuity liabilities, I think typically the way you look at it is if it is the movement of an undertaking, then the gratuity liability moves onward, and the buyer typically takes on the gratuity liability as if the employee never ceased to work, right?
Mm.
In that sense, therefore, when the employee quits the buyer entity, the employee will be entitled to gratuity on the basis of having worked not only in the buyer organization, but also for the period in which he or she has worked in the seller or target organization. That's one aspect of gratuity. When you
Yeah.
do selective hiring, however, then you would look at, say, settling of gratuity on the closing date so that the employee receives gratuity payment to the extent he or she is entitled to gratuity payments and then starts their employment afresh in the buyer entity. And that way, the buyer entity is solely liable for gratuity payments for the period that the employee has worked with the buyer. There is also the element of purchase consideration associated with this to the extent that the buyer is taking over gratuity or similar benefits, then it is right for the buyer to also adjust purchase consideration from the agreed purchase consideration during the course of diligence and structuring.
Yeah. I think we do have time, so I'll just pick two more questions before we move to closing. Uh, can you just recommend some warranties that we should be seeking from founders or investors in the target entity? And if it's the answer is yes, then what kind should of warranty should be looking at? Given it's a very focused deal that we're working with here.
Absolutely. So warranties would typically be tied to our discussions around due diligence. So all the aspects that we covered in diligence should be definitely backed by warranties and indemnities. Within that, there are obviously two baskets, which we typically call the fundamental warranties and the business warranties. For a deal of this nature, the deal warranties include the fact that they have authority to sign, they have obtained necessary approvals, consents. Those are key aspects that you would definitely consider as fundamental in nature. And business warranties include the fact that there are no liabilities, that their financial statements are true, accurate. The employees are indeed employed. There's misclassification aspects of employees versus contractors that need to be considered as part of these represent warranties package. Um, these are by and large the typical reps and warranties. I would say we will obviously have to tailor these reps and warranties package depending upon the target at large as well. Particularly in case of niche industries where AI is at play, data is at play. Uh, those aspects also come into the reps and warranties package.
Yeah. Uh, Vivek, one of the questions is interestingly about tax, and we appreciate that we are not tax lawyers on the call, but apologies if we are putting you in a spot. But what are the key tax considerations that we should be looking out for in acquihire structures? Maybe a few summary thinking points rather than detailed answers, which of course we can leave to our tax teams. But just your thoughts on based on your experience in these deals.
No, absolutely. Thanks, Purti. Uh, yes, I can give a broad overview of what I have seen is the tax applicability here. Obviously, this is subject to more detailed advice. But again, tax depends on the way we structure the consideration, right? If we structure the consideration in the form of solicitation fee, you would typically be looking at indirect tax in the form of GST being applicable on it. That is one element of it. Then there is the other element of it, which is the bit about direct tax on the recipient of the solicitation fee as well.
Mhm.
But more importantly, on the indirect tax element, one key, and it's an important topic you nudge me towards, because oftentimes what we've seen clients getting stuck with in terms of indirect tax on solicitation fees is how does the reversal of that credit work for the uh, for the other entity, right? And that's something that people might want to ponder over. There is a fact-specific response to that, unfortunately, and that must be considered by tax attorneys.
Yeah.
That's on that. Then there is the IP assignment, and then the employee consideration.
Hmm.
Employee consideration is typically payroll taxes in the form of direct taxes, and then IP consideration too will be subject to both indirect tax and direct tax at the hands of the SSEs.
Thanks, Vivek. Fairly detailed on that one. I think last one, interestingly, this question is actually very interesting because we faced it practically. In the past, if you remember, we used to always be worried that an asset purchase deal should not get, a business purchase should not be classified as an asset purchase because then GST triggers there. Here, I think somebody has a very reverse concern. Their concern is that what are the risks of this deal being classified as a business transfer under Indian law? Because that also entails its own complications and answering for the direct tax authority. So, how do you solve for that risk, or do you think there's a huge risk of this being classified as a business transfer, so to say?
No, absolutely. In terms of, I think, business transfer, if you are acquiring the entire undertaking, and if it is a smaller setup, smaller organization, where these employees were the whole and soul of that organization with other minuscule
Hmm.
assets of laptop servers and the like, and you're acquiring all the employees, then you're effectively taking the soul of the organization. In which case, cases in the past have often held that that does get classified as a business undertaking. And business undertaking, as I've mentioned earlier, has one tax connotations to it about how whether or not it is a slump sale. And second connotation is about transfer of undertaking under Industrial Disputes Act, and therefore ensuring one continuity of benefits to the employees and ensuring that the employees, when they are transferred, receive equivalent and no detrimental benefits from what they received at the target entity.
Yeah. Surprisingly, I think there's one more question that has just popped in, and we do have 2 minutes, and let's try to cover it. I think this question is not just specific to this deal. To my mind, it applies in all transactions that we do. Being that if target is wound up, who will indemnify post closing because the target has been liquidated or is under IBC? So, who does indemnify in that situation? I think that is a generic question, but given that somebody's asked, I think it's best that you take it up.
No, very interesting question. So typically we will ensure that the entity indemnifies to the until and unless it is wound up. Now, the moment closing happens in most of these instances, because Indian companies law requires that the company go zero on both liabilities and assets for the purpose of strike off, there's really no
Yeah.
juice left in the company. Then the indemnities would either flow from the investors who have sucked the money out of the company or the founders themselves because they've been in charge of operational control of the company.
Fair. I think Vivek, that really answers all the questions. I don't know if we have to have anything more pending to send out, but we'll give the audience a minute. With that, can we move to the poll, please? Before closing this presentation, everyone in the audience, if I can request you to spend 1 minute of your precious time to answer the poll that's on your screen. Your feedback is very essential, and we take this very, very seriously as part of our continuous improvement program. But Prajay, can you put up the slide, please? Thank you so much for being so participative, everybody. I can see a lot of action already happening in the polls. We'll just give it a minute. Thank you so much to everyone who participated in the poll. Of course, I would like to mention a special thanks to Vivek for sharing his expertise and experience on such an extremely nuanced and well-researched subject. All of us will agree that it couldn't have been more detailed and more interesting. It shows your deep expertise and practical learnings from this space. You were simply outstanding, Vivek. Thank you so much for taking your time. And also, of course, a big thank you to our audience for your attention and your questions, which, of course, we found very interesting to work together. We do hope that you found the webinar interesting and a worthwhile investment of your time today afternoon. We certainly enjoyed bringing it to you. After the webinar, we will send to you a copy of today's presentation materials, summary notes, and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please take some time to send us your feedback, comments, criticisms, and maybe if we request some compliments as well to keep Vivek happy. The form takes less than 1 minute to complete. If you're interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the contact slides at the end of this webinar. Thank you for attendance today, and we look forward to being with you again at the M&A Academy.
Thank you, everyone.
Thank you, everyone.